Okay, my friends, so we did a live stream some hours ago, and there were some technical difficulties. We've been having some thunderstorms and stuff like that here. I don't know if that played into it, but it seemed like either, I don't know if it was StreamYard or YouTube, it was cutting in and out, and at least to me, I feel like it makes it harder to follow, especially if I'm reading and then parts of it cuts out and I keep reading but I don't know it cuts out. Anyway, I just decided to make a video and just record kind of where we left off from episode 5, so that way, whether you were here last night for the live stream for episode 6, the one that I just deleted, or if you weren't here, either way, you aren't going to miss anything. So I'm just going to go over the same documents that I covered, but just there's not going to be any issues because I'm uploading it. So where we had left off from episode 5 was we were covering this gag order. So here we are, to orient y'all for the time, we're in November of 2021. So just a couple months after Maggie and Paul are murdered. But he's not been charged yet with that. But he is being held in custody due to these financial crimes. And I believe it was in episode 4 we watched the bond hearing where he was denied bond, and that was on October 19th of 2021. So this was filed by Alex about a month after he was denied bond and put into custody, basically. So he's there in custody, and meanwhile he's entertaining himself by filing frivolous motions here. So this was the emergency motion for a gag order and sanctions to Eric Bland. And again, we covered the first number of pages of this, and so I'm going to go ahead and scroll to where we had left off at the end of episode 5, and we were on page 11. So here is where we had left off. So here they're basically just saying, of course, part of what he's trying to base this gag order on, of course it was denied, but is that it's hindering his right to a fair trial. So here we've just got some case law supporting that. We are all familiar with that, in terms of prejudicing a jury. We've been talking about that quite a bit with Koberger. So, okay, so here's what we wanted to get to next. So this again is this is what is being alleged by Alex in this filing, this emergency motion for gag order and sanctions. And so here's what he's saying about Eric Bland. Mr. Bland's attacks on Mr. Murdaugh's character and credibility are intended to prejudice this proceeding. As outlined above, Mr. Bland has made a ceaseless barrage of attacks on Mr. Murdaugh's character and credibility. He has, inter alia, stated Mr. Murdaugh is, quote, morally decrepit, a, quote, really, really, really bad person, that, quote, there's no bottom to him, that he, quote, doesn't think decency and rules apply to him, and that he is, quote, a desperate man, and that he is, quote, as morally bankrupt as serial killer Pee Wee Gaskins. The reference to Pee Wee Gaskins was particularly insulting. Mr. Bland is aware that Mr. Gaskins was prosecuted by Mr. Harpootlian. Mr. Bland knows that stealing money is in no way morally equivalent to murdering more than a dozen people and raping girls as young as 12 years old. He knows Mr. Gaskins 2 weeks before his execution plotted to have Mr. Harpootlian's 3-year-old daughter kidnapped, forcing him and his family to live under armed guard at a secure location. Mr. Bland's statement that Mr. Harpootlian's current claim is morally equivalent to the mass murderer who threatened his daughter was meant as a, quote, dig against Mr. Harpootlian as much as a comment about Mr. Murdaugh. So you can tell this was probably Poot writing this because he wanted to make sure he got his 2 cents in about his feelings being hurt. But also, I pointed this out on the live stream again. That's been deleted, so I'll just repeat it. That I also think it's funny because serial killer and a mass murder are completely different things. So, yeah. These highly publicized media statements regarding Mr. Murdaugh are meant to prejudice prosecutors, judges, and ultimately jurors against this should just be jurors, anyway, against Mr. Murdaugh, by publicly vilifying Mr. Murdaugh in the media over a period of months while simultaneously suing him in a legal proceeding. Mr. Bland hopes to prejudice the legal proceedings to award him and his client more punitive damages by inflaming the jury pool and by making it impossible for Mr. Murdaugh to say or do anything to mitigate his alleged actions. Mr. Bland does not care that a collateral effect of his smear campaign will be to prejudice criminal, highlighted here, legal proceedings against Mr. Murdaugh, which share the same jury pool. 2. Mr. Bland's attacks on the character. Boy, they're really wanting to pretend like Alex does have any type of character here. On the character, credibility, and reputation of Mr. Murdaugh's counsel are intended to prejudice this proceeding. Mr. Bland, perhaps finding it unsatisfyingly easy to pummel the character of an incarcerated opioid addict who allegedly stole millions, has also engaged in a campaign to disparage the character, credibility, and reputation of his opposing counsel. Again, this is Dick and Jim being like, you're saying mean things about us or whatever, or like you're making us look bad. Mr. Bland has engaged in gratuitous public speculation about what attorney's fees Mr. Harpootlian and Mr. Griffin supposedly have received. Mr. Bland has publicly questioned why Harpootlian and Griffin are representing Mr. Murdaugh. Mr. Bland has publicly mocked the pleadings and motions that Dick and Poot have filed in court on behalf of Mr. Murdaugh, calling his habeas petition, quote, a desperate act by a desperate man, and saying, quote, I didn't think anybody had the set of balls to file this motion to dismiss. Oh, I love it so much. And saying, oh, wait, I already read that. Mr. Bland has mocked Mr. Murdaugh's counsel for, quote, just winging it without a plan or a grand strategy. Mr. Bland claims opposing counsel cannot achieve anything for their client in this matter because the case is too high profile to, quote, leverage relationships in the darkness of a judge's chamber, accusing Dick and Jim of ordinarily relying on ex parte political influence rather than effective advocacy in a courtroom to achieve results. Such comments do not assist the court in finding the truth of the matter before it because they have nothing to do with the dispute before the court. Mr. Bland's opinions of Dick and Poot's abilities, litigation strategy, fees, court filings, or client selection decisions are completely irrelevant to plaintiff's claims. His vitriolic public attacks on opposing counsel are a tactic to belittle the character of his opposing counsel in the eyes of the jury pool. They are also meant to incite public opinion, to pressure the court to rule against Mr. Murdaugh's lawyers on disputed matters properly decided solely on court filings and proceedings in open court. Mr. Bland has disclosed information that would be inadmissible at trial, including statements about criminal charges, for the purpose of prejudicing this proceeding. Mr. Bland has publicly speculated about what evidence the state grand jury has reviewed and what indictments it may issue in the future based on conversations with Creighton Waters, the prosecutor leading the state grand jury proceedings about this purportedly secret proceedings. He has publicly speculated without any evidence whatsoever that Mr. Murdaugh murdered plaintiff, a clear attempt to garner more punitive damages in favor of her estate. He has explained that Mr. Murdaugh's victims did not die in vain because their deaths helped bring down Mr. Murdaugh. He also congratulated a local reporter, Manny, for being the spark that lit the fire taking down Mr. Murdaugh. He has repeatedly asserted that Mr. Murdaugh is guilty of murderous, yet to be charged felonies. Or sorry, not murderous, numerous. Well, murderous also, but he didn't know it at the time. He has speculated that Mr. Murdaugh will be sentenced to prison for hundreds of years in prison for crimes charged but not proven. None of this or of Mr. Bland's many other similar statements could ever be admissible at trial. Mr. Bland's intent is to use the media to place these statements before the jury pool because no judge would allow him to do so in a courtroom. No exceptions apply to Mr. Bland's inflammatory rhetoric. Mr. Bland's disparagement campaign does not fall within the exceptions under Rule 3.6b under the Rules of Professional Conduct. As shown above, he goes well beyond identifying the claims and defendants in a case, disclosing information already in the public record, merely stating that an investigation is in progress, merely stating the results of the steps of the litigation, requesting assistance in gathering evidence, or warning of imminent danger from a person involved in the litigation, which would be impossible as to Mr. Murdaugh since he is in custody. A gag order is required. The rules governing lawyers in the state have an unambiguous rule against Mr. Bland's conduct. Mr. Bland's very public refusal to obey the rule that brings the legal profession into disrepute. Like, this is so hypocritical, right? Like, they're saying Eric Bland is bringing the legal profession into disrepute. That's hilarious. Failure to enforce the rule would further bring the legal profession into disrepute. If lawyers do not obey their own rules for their own conduct, my fucking God, the nerve, though, to say this. The public will not accept lawyers enforcing the rules regarding other persons' legal rights and obligations. I can't even believe they're saying this. The sound administration of justice requires lawyers representing litigants. This is insane, sorry. To be rule followers. Not freelance pundits who insult opposing counsel to entertain a peanut gallery. Quote, the very word trial connotes decisions on the evidence and arguments properly advanced in open court. Legal trials are not like elections to be won through the use of the meeting hall, the radio, or the newspaper. Okay? Mr. Bland has made it clear he intends to continue and indeed to escalate his campaign of extrajudicial disparagement so long as no one stops him. For that reason, a gag order is unfortunately necessary to enforce a rule of professional conduct that lawyers are expected to follow voluntarily. Conclusion. For the foregoing reasons, the court should grant this motion and enter a gag order prohibiting Attorney Eric Bland, counsel for plaintiffs, from making any further statements to the media concerning defendant or his lawyers while this action remains pending that do not fall within the exceptions allowed by Rule 3.6b. And also, they're saying, should sanction Mr. Bland by awarding defendant costs and reasonable attorney's fees incurred in making this motion, and referring Mr. Bland's conduct, this is hilarious, referring Mr. Bland's conduct to the Office of Disciplinary Counsel and taking such other actions as the court deems appropriate. Well, those actions are going to be to deny this motion. That's what's going to happen. So, there you go. All right, on to the next one. Here's this confession of judgment. So here we are. It's March 24th, 2022. So this is a couple months later from the document that we just, from the gag order, right? The gag order was November 2021. So here we are. We're in March 2022. So here we go. So we've got the caption here, confession of judgment. So Richard Alexander Murdaugh, on behalf of himself, his estate, his heirs, hereby jointly and severally confesses judgment to Michael Tony Satterfield and Brian Harriet and their respective heirs in the amount of $4.3 million, inclusive of all prejudgment interest, attorney's fees, filing fees, and service fees, executed on the date, even herewith and in accordance with South Carolina Code, for a confession of judgment to be legally binding as set forth herein. By this stipulation, the parties hereto accept and stipulate to the process set forth herein, through which the judgment may be paid in whole or in part from the proceeds, if any, collected by the court-appointed receiver John T. Lay. So this is just, that's the receivership, right? So debtor is a citizen and resident of the state of South Carolina. Debtor admits liability to the judgment creditors for the claims asserted against him in their complaint, which is the civil action, which is this same case number. Debtor and judgment creditors hereby acknowledge, agree, and stipulate that this judgment is subject to and restricted by the receivership implemented by the court as to the debtor's assets in that certain order in the case caption. So then, of course, like I said, it's going to refer to the Mallory Beach case. Debtor confesses and authorizes the entry of judgment in favor of the judgment creditors in the amount of $4.3 million. Judgment creditors and debtor agrees and stipulates that the amount of payment, if any, from the money is recovered by the receiver in full or partial satisfaction of the judgment shall be determined according to the terms. I think it's so interesting. I mean, I know this is probably standard, the payment, if any, but when it comes to Alex, just because we know that he stole all this money and we don't know where it went, right? And then on top of that, we know that even with that being the case, he was moving assets around to try to hide, as they said, hide money from the boat case, right? During that discovery. But even prior to that, right? Like, we know he was having to, to quote Mark Tinsley, steal from Peter to pay Paul. So that's why every time I read this, and I'm like, the amount, they're talking about the money, like, if any, is just so interesting, because it's like, he knows there's not going to be, anything there. All right. So, if any, from the monies recovered by the receiver in full or partial satisfaction of the judgment shall be determined according to the terms. And again, partial satisfaction, again, that word is there as like a stipulation, like in case there's only $1, that's with all they can get, right? Type of thing. Partial satisfaction, because the judgments were $4.3 million, right? So that's why I say partial satisfaction of the judgment shall be determined according to the terms of this confession of judgment and stipulation. In determining the amount of the payment, again, if any, to which the judgment creditor is entitled from the funds recovered by the receiver, the parties hereby acknowledge, agree, and stipulate as follows. So this is basically just saying the receivership is going to be determining this and being charged with liquidating those assets. This is all just, none of this is really quite relevant to what we're looking at here. This is all, again, just dealing with the receivers. Debtor and judgment creditors agree and stipulate that this confession of judgment is not in any way an attempt to obtain or establish preferential rights for the payment of monies to judgment creditors in satisfaction of the confession of judgment relative to other current and future claimants and creditors of the debtor. Debtor further agrees that in the event he files for protection under any chapter of the Federal Bankruptcy Code or any state debtor-creditor act, this judgment shall not be dischargeable under any circumstances under the terms of the final bankruptcy plan or order, and further, debtor agrees to waive the automatic stay with respect to efforts to collect the same. Debtor further agrees that this confession contains an admission that the judgment is the result of the debtor engaging in a defalcation while acting in a fiduciary capacity. This is important because this is an admission, right? Thus, in the event that the debtor files for protection under any chapter of the Federal Bankruptcy Code or any State Debtor Creditor Act, this judgment shall not be dischargeable under any circumstances under the terms of the final bankruptcy plan or order and pursuant to section blah blah of the United States Code of Laws. Okay, so here's talking about any transfers. I don't know that that's all that important. This part, though, is interesting. By entering into this confession of judgment, debtor is not consenting to the appointment of the receiver and does not waive his right to challenge any action taken by the receiver as it pertains to Alex Murdaugh's authority to renounce his interest in the estate of Maggie Murdaugh. So, I guess at this point, he's still trying to kind of hold on to any type of authority when it comes to that. The undersigned agrees and affirms that he will not challenge or contest in any way his capacity or authority to enter into and execute this confession of judgment and stipulation. Debtor has been represented by his own legal counsel, so he's got counsel. That's all that says. Dick and Jim, blah, blah, blah. And that's basically all that is. That's it. So there we go. So here's where things start to get a little bit more crazy. So now we're in May of 2022. So this is May 11th. So this was filed, 3 weeks or something after the confession of judgment. So here we're back to the Nautilus Insurance Company. So if you remember from back at the very beginning of this series, and actually all the way through, we've been revisiting it, but Alex had that verbal, recorded interview with the insurance adjuster. That was from Nautilus. And then we also went over the document from the Nautilus insurance adjuster, the document that included updates to Alex's statement and then also the statements from Maggie and Paul. We went over all that. So this is, I'm just saying that to explain that it's the same insurance company, Nautilus. So there's a couple different things going on, right? We've got, the Satterfield estate, right, suing Alex. And then we've got the criminal charges being brought for these financial crimes. And then we've got Nautilus here suing Alex and co. This is, again, he still has not been indicted for the murders. That does not happen until July of 2022. So he's still got 2 months or so of thinking he could maybe get away with it. So anyway, all right, so what's interesting here is in this filing, we have Nautilus being the petitioner, right? They're bringing the complaint. And then we have Alex, and then Corey Fleming, Moss and Kuhn, all the same people, Palmetto State Bank, and you might notice the United States of America. So what's noteworthy here is this is a federal case. So different from what we saw, like, for example, with the Satterfield complaint against Alex. Those are being done in the state. So here you can see United States District Court for the District of South Carolina. So whenever you see District Court, it's federal. But we're going to be talking about that here in a second, why that is. But that's not the reason that this United States of America is listed. But we'll get to that in just a second as to why they are they're a respondent, not a defendant in this particular matter. Comes now Nautilus Insurance Company amending its pleading pursuant to Rule 15, blah, blah, complaining of and seeking relief from all defendants except the United States of America. So in other words, again, like I said, they're not defendants. Requesting a declaration as to its rights and obligations with regard to a grand jury subpoena issued by the United States of America. Nautilus's grounds are as follows. So, parties and jurisdiction. So this is going to kind of explain why this is a federal complaint here. Nautilus is an insurer organized under the laws of Arizona with its principal place of business in Scottsdale, Arizona. Alex Murdaugh is a citizen and resident of Colleton County, South Carolina, and at all times relevant here too was an attorney, was licensed to practice law in South Carolina. Corey Fleming, citizen and resident of Beaufort, again, was an attorney licensed to practice law in South Carolina. Moss and Kuhn, was the blah, blah, blah. We already know what they are. Chad Westendorf is a dickhead. Sorry, it doesn't say that. Is a citizen and resident of Hampton County. Palmetto State Bank really fucked up when they helped Alex do all this shit. Is also a South Carolina corporation and chartered banking institution with its principal place of business in Hampton County. And then here we go. So the United States has subpoenaed records from Nautilus regarding coverage it issued to Murdaugh. Here. The court has jurisdiction, so this is subject matter jurisdiction, pursuant to the code inasmuch as the plaintiff is a citizen of a different state than each of the defendants, other than the United States, of course, is a citizen of, and the amount in controversy exceeds $75,000. So they're just establishing the jurisdiction that this should be brought into a federal court, because you've got the parties, again, being citizens of different states, and then you've got an amount in controversy exceeding $75,000. That's the threshold for a civil case to be brought into federal court. The court has jurisdiction over the plaintiff's declaratory judgment claim under 28 U.S. Code as that claim raises a question under this court's supervisory power to regulate the manner in which the federal grand jury investigations are conducted, and the court has jurisdiction over the plaintiff's remaining claims under, and then another U.S. Code. So here's where it gets interesting. So factual allegations. Nautilus issued umbrella policy to Murdaugh, providing $5 million in umbrella coverage to Murdaugh subject to the policy terms. A copy of the policy is attached as Exhibit A. On February 2nd, 2018, Gloria Satterfield, she died on February 26th, 2018, Murdaugh made a claim for coverage under the policy with regard to claims against him purportedly on behalf of the estate of Ms. Satterfield. Nautilus provided defense counsel for Murdaugh and ultimately paid in excess of $75,000 to resolve what it then believed to be claims by the Satterfields. And I think the reason he's saying that is because they were being told that the Satterfields were involved in any of the decision making, but of course, as we know, what really was going on was Chad Westendorf and everybody else were just doing things without Tony's knowledge or consent, and same with Brian Harriet. They had no idea what was happening, and they were just doing things without them. So, beginning in July 2021 and continuing through the filing of this action, Nautilus became aware for the first time of facts regarding the Satterfield claims, allegations of insurance fraud, conspiracy to commit insurance fraud, and allegations of criminal conduct, which they're calling, this is so funny, they have this little nickname for it, the irregularities. Hilarious, right? With the capital I. The irregularities, so to speak, include. It's funny, you could also say this is kind of like in our document we've got going on, we call it the inconsistencies. So maybe something similar. So A, that it was Murdaugh who approached the Satterfield family after the death of Gloria Satterfield and suggested they sue him and collect from his insurance companies, including Nautilus. That B, that Murdaugh arranged for Fleming, his longtime close friend, and MKF, Moss, Kuhn, and Fleming, to represent the Satterfield family in bringing a claim against his insurance. C, that Murdaugh and Fleming arranged for Westendorf to serve as the personal representative of the estate of Gloria Satterfield in exchange for a fee, as they had previously done with other officers and directors at Palmetto, effectively removing the Satterfield family from the proceedings. So that's what I was referring to just a second ago when I said right here, they believed that this was being done by the Satterfields, but of course, when indeed it was not, because they were removed from the proceedings. Here we go. Yeah, that unbeknownst to Nautilus, Murdaugh was not a bona fide insured seeking coverage, but rather was coordinating the handling of the claim with Fleming, including sending correspondence related to the case to Murdaugh's firm's letterhead, PMPED letterhead, and preparing and delivering disbursement sheets such that Fleming and Murdaugh were effectively co-counsel. That Murdaugh pressured Nautilus to settle the claim, threatening a suit for bad faith against Nautilus if it refused to pay policy limits. So this is important because we talked about this, how typically what happens is the insurance company is going to do a big investigation. They don't want to have to pay, right? And there were a lot of things that were weird about this entire situation because they didn't really look into things thoroughly. And it was clear, and we kind of talked about it, how it was clear from the document that we read that the Nautilus insurance adjuster seemed to be kind of like, I don't know if I believe this. It was like, I'm not sure. There was a weird tone that seemed like he thought something was kind of fishy. And like we went over, there were times where like verbs were missing, where it was something really important. I think it was like he intended to get an answer from Alex and then go back and fill it in, and then he never got a straight answer type of thing. But this makes sense, right? So Alex pressured Nautilus to settle the claim, threatening a suit for bad faith against Nautilus if it refused to pay policy limits. But it gets worse. That Murdaugh was abusive toward the Nautilus adjuster handling the claim and demanded Nautilus pay its full policy limits, threatening that if the case against him were filed and it went to trial, he would admit liability and the judgment would be substantial. So there you go. That Murdaugh was abusive towards the adjuster. That the monies contributed by Nautilus as a result of the foregoing in settlement of the claims by the Satterfield family were deposited by Fleming into MKF's trust account, but were never received by the Satterfield family. Instead, Fleming dispersed the funds minus fees of over $600,000 to an account created by Murdaugh in the name of Forge, fake Forge, and controlled by Murdaugh. That no effort was made, letter H, that no effort was made by Westendorf, Palmetto, Fleming, or NKF to ensure the funds intended for the Satterfield family were received by the Satterfield family, violating their obligations regarding escrow funds and their disbursement. All right, number 15. Through the irregularities and other actions, Murdaugh and others, including Fleming, MKF, Westendorf, and Palmetto, collectively the co-conspirators, coordinated efforts to improperly obtain insurance money and disperse insurance proceeds for their own personal gain and at the expense of Nautilus. The irregularities led to Murdaugh and Fleming being suspended from the practice of law and indicted. There we go. Very good. The irregularities took them down. The irregularities shone a different light on some of the facts and circumstances surrounding the claims, such that now it is apparent that these facts and circumstances were misrepresentations. Another word for that is lies, or concealments of the truth. Were deceitful, yep, and were intended to mislead, obscure, and dissemble, including. So these are the things they're saying are lies, misrepresentations, concealments of the truth. A. That immediately following Gloria Satterfield's fall on February 2nd, 2018, Murdaugh rushed to the scene, arriving before EMS. On March 29th, 2018, Murdaugh stated that Miss Satterfield briefly regained consciousness, during which time she stated that Murdaugh's dogs had caused her to fall. This statement was heard by no one else, and is contradicted by Miss Satterfield's later statement to the hospital staff that she had no idea what made her fall. Letter B, that on March 29th, 2018, Murdaugh claimed Miss Satterfield was at his property, not to perform work for Murdaugh and his family, but to collect a check for work performed for someone else, thus avoiding a workers' compensation defense. C, that Murdaugh stated to multiple third parties in Hampton County that he was liable for Gloria Satterfield's fall and ultimate death, an admission against interest that all but ensured there could be no challenge to liability, and securing his ability to force Nautilus to contribute settlement funds that Murdaugh and the co-conspirators stole. It's really quite insane, the whole thing. So, it's like they couldn't, Alex and co. couldn't have stolen the money if Nautilus didn't pay, right? So it's the thing that's so unusual is that what was really important here is Alex had to make sure that he was found liable, right? Again, it's this whole thing about it's admission against interest. It's just so unusual. He wanted to be found liable because if the insurance company had done a more thorough investigation, had they not been threatened or abused, perhaps, as alleged here in this document, they might have discovered that there were other things here, right? Maybe if she was doing legitimate work there, for example, it would have been a workers' compensation defense, and therefore they wouldn't actually be liable. They, as in Nautilus, or maybe if they had found, this wasn't the case, but just hypothetically, right? Had they found that Gloria did have some sort of health condition or something like that could have caused her to fall, again, that would be a difference, or that, the dogs were never there or whatever, or maybe something else happened that caused her to fall. But what was really important for Alex was he had to make sure that he was found liable, and that way Nautilus would definitely have to pay out, and that way he could steal the money. Because if Nautilus doesn't pay out, they can't steal it. So that's the whole point here. Number 18, Murdaugh filed a proposed confession of judgment on March 24th, 2022. That's what we just read. In case number blah, blah, in the state court of South Carolina. Again, they're citing this because of the fact that we are in federal court here for this document. And again, that confession of judgment was for state court because that was just dealing between him and the Satterfield boys. Again, that's just, I think I already mentioned that, but just to reiterate that we've got the state proceeding and then we have this as federal again because of the subject matter jurisdiction being in different states. So prior thereto, co-receivers were appointed by the state court in Hampton County to administer Murdaugh's assets and claims against Murdaugh. The order appointing the co-receivers purports to require that any party obtain leave of the state court of consent from the co-receivers prior to suing Murdaugh outside of that jurisdiction. Though disputing the validity of that requirement in the state court's order, Nautilus obtained the consent of counsel for the co-receivers prior to suing Murdaugh in this action. All right, first cause of action, fraud, Murdaugh. They are synonymous with one another. Okay, so this is just, again, this here is going to be old, just things are repeated. But here's the best part, right here. Nautilus believed the claim against his policy was brought at the behest of the Satterfield family. The scope of Murdaugh's depravity is without precedent in Western jurisprudence. Bam. Let me read that again. Get it, Nautilus. The scope of Murdaugh's depravity, I love this, is without precedent in Western jurisprudence. That's one way to say it. He and his conspirators disguised that they were making the claim under Nautilus's policy for their own benefit. What's really funny too, sorry, let me just go ahead and say, again, he's not been indicted with murder yet. And already, right? Like, yes, all this is true, but it does get worse, and that's the crazy thing, right? All right, in the events as foresaid, Murdaugh knowingly made false numerous statements to Nautilus, to wit, on March 22nd, 2018, Murdaugh represented to the Nautilus claims adjuster that he sought coverage under the policy in order to protect himself from the losses of the Satterfield estate in the action, and that he was liable to the Satterfield estate for the policy limits. In fact, it was he himself who sought to obtain payment for the insurance funds in the action, as he intended to, and ultimately did, divert the funds to himself and his co-conspirators, rather than use them to satisfy the estate's claims. On or about March 22nd, 2018, Murdaugh stated to an independent adjuster, the poor fellow who was threatened, with the intent that Nautilus would rely on his representation, that shortly after the purported fall, he heard Miss Satterfield say that Murdaugh's dogs had caused her to fall. Miss Satterfield made no such statement and later told the hospital staff she did not know why she had fallen. This is going to come up later. This whole thing about the dogs is going to come back to the dogs. Just wait. There's a reason all this matters, and it's an ongoing thing still, even. But it's important here that in this document, what this document is stating, it's saying, essentially the dog's story is bullshit, basically, comes down to, which is what, we've determined it, but it's going to matter whether it is or not. So Miss Satterfield made no such statement and later told the hospital staff she did not know why she had fallen. Murdaugh repeated the statement on March 29th during an interview with Bryant McGowan, an insurance investigator, again with the intent that Nautilus would rely on the representation. On or about March 29th, 2018, Murdaugh stated to Bryant McGowan that, on the day of the purported fall, Miss Satterfield was at his property not to perform work for Murdaugh and his family, but to collect a check for work performed for someone else. Again, trying to avoid that workers' compensation claim. In fact, she was, and let me just reiterate. What's the problem with that? Well, it means that they would pay out. So, it's not like Alex would have to, it's not like he was avoiding it because he would have to pay. It's not that. It's just that if that happened, he couldn't steal from it. He would have no ability to get his paws on those funds if it was workers' compensation. So that's why. In fact, she was there to perform work herself. Murdaugh intended that Nautilus would rely on this representation. On or about April 22nd, 2019, Murdaugh represented a counsel appointed by Nautilus for his defense that Nautilus should disperse funds for the settlement of the action to Westendorf and MKF, and that the funds so dispersed would be distributed to the Satterfield estate. In fact, he intended for the funds so dispersed to be distributed to himself and his co-conspirators, and the funds ultimately were so distributed. Number 23, Murdaugh made false statements knowing that they were false and intending that Nautilus would rely on them. He's a fucking liar. Specifically, he sought to mislead Nautilus and force it to contribute to a, quote, settlement, end quote, that was not real. A fake settlement, kind of like a fake forge. 24. Nautilus relied on Murdaugh's false statements to its detriment and dispersed funds under the policy for the, quote, settlement, end quote. I love that they're like, we're not even calling it a settlement anymore because it wasn't real. Based upon the fraud and deceit directly and proximately causing damage to Nautilus. 25. Nautilus is entitled to punitive damages. 26. Nautilus requests the court adjudicate whether Murdaugh defrauded and deceived Nautilus by its actions. I mean, it clearly did. The claim is unique to Nautilus and it has not and could not have ever been brought by another person or entity. So, a second cause of action, so conspiracy to commit fraud for all defendants except the United States. Can you picture the United States as like the country? It's like, but it's wearing like a burglar, like a bad guy, like hat with like the glasses. Like I'm picturing the type that's on that sign you see, well, don't see very often, but every now and when it's like there's a burglar afoot or something like that, and it has that funny little cartoon. You know, you all know what I'm talking about, hopefully. Anyway, I'm picturing the United States but wearing that type of outfit, which is pretty funny. All right, so again, that's going to be the same thing reinstated here. And this is all basically just the same type of thing. It's just they have to state each separate cause of action as a separate cause of action, right? It's a separate, that's how it is. And it ends up being a charge, right? Like as we know, he ended up with over 100 of them by the end. And so again, here's another one. Same thing. All defendants except the United States. Fourth cause of action, declaratory judgment. And that's basically the end of that. So next, what we're going to do is we are going to read the policy that we have and see what exclusions apply, if any. So this is from his Nautilus umbrella policy. So here's the exclusion. So the following is not covered under coverage A. 1. Any obligation for which the insured or any carrier or his insurer may be held liable under any workers' compensation. So there it is, the workers' compensation. That was the big thing, right? That's why it had to be a check from his mom. Unemployment compensation or disability benefits law or any other under any similar law. Bodily injury or property damage which is expected or intended from the standpoint of the insured. This exclusion will not apply. Blah, blah, none of that really matters. And then here, it is of note because remember with the Mallory Beach with the boat case, he was required to have a certain amount. We heard actually about this in the trial because Mark Tinsley talked about it. Remember, he was required to have a certain amount of coverage that would be enough for like watercraft shit. And remember, part of the problem was that Nautilus was the policy he had that really covered that. And with the Gloria Satterfield, with this payout, that policy, I believe it was just terminated, and that would have been, or it reached policy limits, you know, so it was before they even knew it was fraudulent or stolen or any of that, like, because again, the boat case happened in 2019, and they didn't know about anything being stolen or fraudulent until 2021. So even without that being the case, it's just the policy limits were reached and it was all stolen, right? But because of that, it terminated his coverage. And so that was part of the thing where it was like, well, the other insurance that he had wasn't the type that actually was really covering watercraft. So that's where this kind of matters because it deals with watercraft and all that. This would have been the insurance policy that would have actually had been able to pay out in that case had it still been in effect. So yeah. So where we're going to be picking up next time, you guys are not going to want to miss it. It's going to be insane. We're getting to one of the most exciting parts. So this is going to be May 1st, 2023. I'll just show you all a little teaser so you can see what's coming up. So this is right after the trial. He's convicted, right? So he's in prison filing another document here to the court. And it's the answer to the amended complaint. So what's happening is he's finally answering Nautilus's complaint, which is what we just went over at the beginning of the video after the confession of judgment. So remember, this is from the Nautilus. So this is the federal complaint, Nautilus against Alex and Co. And then this is his answer. And what's interesting is, of course, knowing that it's after the trial, we know that he admitted a bunch of things on the stand, trying to make it seem like he would be honest about not murdering Mags and Pawpaw. So that's what we will have coming up next. And that's it for this video. So hopefully we'll have fewer technical difficulties on the next live stream. But I thank you guys for watching. Hopefully you feel like you learned something. And I'll see you guys on the next video.